This is an interview with Robert Khuzami for the SEC Historical Society. I'm Harwell Wells, and we're in New York City on February 15th, 2019. Thank you so much for taking the time to talk to us.
Great, looking forward to it.
So we like to start off our interviews with a little background on the people we're talking to, where they grew up, where you went to college and law school. So if you could talk a little about sort of where did you grow up and go to university?
Sure, I grew up in upstate New York, outside of Rochester, and I went to high school there. Took a little time off to paint houses and tend bar, and then spent my first 2 years at a small State University of New York school, SUNY Geneseo, south of Rochester, and then transferred to the University of Rochester, where my mother was a secretary there, and at least in those days, they gave a significant tuition waiver for the sons and daughters of staff. So I spent my last 2 years there, and then took another year off, mostly to save money, and then went to Boston University School of Law.
Why go to law school?
Law had always been an interest of mine. I think partly I was probably influenced by people who used to say that my father would have made a great lawyer, who immigrated from Lebanon and never got past the 8th grade, but he was very analytical and loved the law and politics. I think it was that, and I think it was also, oddly, Watergate, which, I, as much of the nation, were fixated on, the televised hearings through the House Judiciary Committee and people like Sam Ervin and others, and watching that process unfold sparked my interest. Of course, most of the people who had violated the law were lawyers, but at the same time, those who were vindicating the system and pursuing justice, conducting the investigations, were also lawyers, and so that got my interest as well.
So when you went to law school and during law school, were you interested in investigations, in public service?
I was interested, I think, generally in public service, but probably like others, I went into law school without a whole lot of insight into what lawyers actually do. No one in my family had been a lawyer, and I don't know that I even knew any lawyers personally, but I was open. I think as time went on, I became more interested in public service, but I can't say that it wasn't a dominant thought in my mind while I was in law school.
And after law school, I gather you clerked for a year and then spent a number of years at a private firm.
That's right.
Why take that particular path?
Well, I clerked. I was interested in clerking and stumbled onto a clerkship in the 8th Circuit through a very odd set of events, primarily that I wasn't such a great law student that I could get a clerkship in New York or Boston or any of the more prominent courts. So I papered the country with my application, and I ended up getting a call from a judge in Kansas City who said, well, every year I hire 3 clerks, one from the West Coast, one from the East Coast, and one from my alma mater, the University of Missouri at Columbia. He said, I have my West Coast clerk and my Columbia clerk. All I need now is one from the East Coast. And I said, well, that's one qualification I can satisfy. He hired me. And oddly enough, I then realized, because he said he had 3 openings, that I had applied to him when he was a district court judge, but he had been promoted to the 8th Circuit in the middle of my application process. So I ended up with an 8th Circuit clerkship that I didn't even really apply to. But in any event, I had a great time in Kansas City, and then went to a firm. Look, money was a pressing concern, and so I needed to pay off loans. I stayed at Cadwalader for nearly 6 years, lived in a $300 a month studio in Park Slope, paying off my loans, and then was able to take the salary hit, should I choose to go into public service.
And I believe you joined the U.S. Attorney's Office in the Southern District at that point.
That's right. On my second try, I got in. The first time I was turned down by Rudy Giuliani, who was then the U.S. Attorney, but made it the second time around, and I joined around September of 1990.
Was he the one who hired you the second time, or had he moved on?
He had moved on. And so that change benefited me.
So why a prosecutor's role if you wanted to leave private practice and go into public service?
Well, look, that's an office that has a very rich history and a real culture of excellence, and very significant and impactful cases. The people who have worked there have gone on to be, luminaries, on the bench, in the bar, and in further public service. It attracts, very talented and eager folks who come in for only, 5, 6, 7 years, work extremely hard to make cases. Because it's in New York, it's the place that you want to prosecute crimes and criminals. New York is the best place to do it because whatever the category, be it organized crime or terrorism or white collar crime or public corruption, there's a very significant, challenging cases that go on within New York, and so I was attracted to all of that.
Okay. And I know eventually you moved to become head of the Securities and Commodities Task Force within the U.S. Attorney's Office, but it's my understanding you had a fairly wide range of cases before then. You didn't focus on that area initially.
No, you do rotations in that office, and I started out in the usual rotations of general crimes, which does a smattering of bank fraud and immigration fraud and credit card fraud and little tax fraud and firearms and low-level narcotics. You're there in that first year and a third to gain trial experience, just understand the process. Then most people go to narcotics unit and then to one of the senior units, terrorism, public corruption, money laundering, securities, etc. I skipped narcotics and went to what was called the major crimes unit, where I focused a lot on money laundering, did a very large money laundering case involving the laundering of drug proceeds through New York's Diamond District, taking in drug money and then transacting in gold and precious metals to clean the money and disguise its origin. And then in February of 1993, the Trade Center was bombed for the first time, and I was assigned to what was the follow-on case to that. The first case charged the 4 individuals who were charged with actually planting the bomb in the Trade Center, but there was a subsequent plot to that, spawned really because the 4 individuals had been apprehended, kind of a retaliation plot that the group had planned to blow up the FBI headquarters, the Lincoln and Holland tunnels, and the United Nations. And that was led by Sheikh Omar Abdel Rahman. And I did that case for 3 years, ended in a 10-month trial, the largest terrorism trial in the history of the U.S. at that time, convictions across the board. And then when I finished that case, I went to the securities unit and then eventually stayed long enough to become chief.
Were you attracted to, was there a special interest in the securities unit? Was it just the next step to take at that time?
No, I was attracted to white-collar crime. Some of it was because I had done that at my law firm. Some of it was because, candidly, it holds a little bit of a special place of personal outrage and animosity for those who have many advantages in life, be it education, job opportunities, stable families, who nonetheless choose a life of crime. And after you'd spent a lot of time, doing other violations where you see people who come from such difficult backgrounds and upbringings, I really wanted to pursue white-collar crime. Also, intellectually, it's very challenging because you're dealing with often with questions of intent and knowledge, and you're engaged with some of the most sophisticated defense lawyers, and you're engaged in crimes and investigation where people are often preparing their defense at the same time they're committing the crime. A bank robber doesn't really think so much about the alibi when they go in to rob a bank. Somebody who's engaged in insider trading, however, may very well, pull some research down from the internet, put it in a file, and say, well, the reason I bought IBM was not because I got a tip from my friend who works in the HR department there, but because I've been doing my research. And they point to the file and they say, here's my research to prove it. So you get in various ways targets of those investigations who are preparing their defense at the same time they commit the crime, and that makes it challenging.
That is actually fascinating. It had not occurred to me before. So obviously at this point you must have begun interacting with attorneys from the SEC, I don't know whether it be the New York office or Division of Enforcement in D.C. At that point, we're talking the mid-1990s. What was your impression of them? How did you work with them?
Yeah. I was there probably late 1990s and early 2000s. Look, there's a long and strong and very fruitful relationship between the SEC and the U.S. Attorney's Office in New York. The U.S. Attorney's Office had the first securities fraud unit in the nation, started really in the 60s, and had been working closely with the SEC for, at that point, 40 years. And so a lot of the kinks had been ironed out, and we each understood each other's concerns and considerations and imperatives, but all with a joint approach to prosecuting securities crimes. There can be some complicated issues, obviously involving parallel proceedings and grand jury secrecy and the like, but we had been working together long enough that a lot of those things had been ironed out. And I will tell you that the SEC folks, are critical to the criminal securities law enforcement mission, because quite honestly, criminal prosecutors don't understand the nuances of Title 15 and the particular statutory violations that exist there. And there's a whole regulatory framework, there's a whole regulated industry that how it operates. The criminal prosecutors, they haven't been studied, even those that are in the unit are there for maybe 2 or 3 years and might have done some work in the area before that, but they really come in as criminal prosecutors who look at everything through the lens of, did they lie, did they cheat, did they steal? And they understand wire fraud statutes and mail fraud statutes and conspiracy statutes, but they don't understand the nuances of the regulations or the Title 15 prohibitions. And so we used to make a joke about how it's the Securities and Commodities Fraud Task Force, but we really didn't understand little about securities or commodities. We relied on the SEC and the CFTC to educate us. And so the SEC, played a very important role, and that's when I first spent a lot of time with both the New York office, the home office in Washington, as well as members of the regional offices, because New York did cases with the offices across the globe. We also hired SEC folks to come work in the U.S. Attorney's Office, either as a kind of a special AUSA for particular cases, and a number of those folks later became full-time AUSAs in the office, one of which later led the Securities Fraud Task Force, Bill Johnson. But there were 3 or 4 or 5 during my time there who came and worked, and they provided great value.
Terrific. So it must have been an extraordinary period at the Southern District, or the U.S. Attorney's Office for the Southern District, but you chose to eventually leave and go back to the private practice of law. But you didn't go to a law firm. You went to Deutsche Bank.
That's right.
And why leave the U.S. Attorney's Office, and why make the turn to Deutsche Bank?
Well, first of all, I've been to the U.S. Attorney's Office at that point 11 years, give or take, maybe close to 12, which was longer than the average tenure and probably longer than I had planned. But, the World Trade Center bombing case took up 3 years, and then, there was a path to possibly becoming chief of the frauds unit. And once that happened, you want to and you need to spend a couple years in that job. And so it was time, to leave. And as far as my next step, I was always interested, in part because of the securities, but I was very interested in the business side of law and being an in-house lawyer and working closely with, the desks and the front office in all sorts of financial transactions or the financial business. And so it was attracted me. And also I teamed up with Dick Walker, who Dick had been head of enforcement when I was chief of the Securities Fraud Unit, and we had known each other from Cadwalader, where we had both been earlier. And so we both left kind of the same time, and we sort of decided maybe we would kind of join together and offer our services, he as the civil enforcement authority and me as the criminal securities authority, to law firms or others. And we were talking to various law firms, but then Deutsche reached out, in part because Deutsche was expanding very rapidly in the United States. They were really just a really a New York branch of a German commercial lender for the most of its time in New York. But in rapid succession, it had bought Bankers Trust, which itself had just bought Alex Brown, a regional broker-dealer. They bought Scudder. They bought Morgan Grenfeld. They bought Reef. They made a number of acquisitions, and what they had was, a legal department that consisted of pockets of lawyers, whose real allegiance was to the former entity rather than to the new combined Deutsche Bank entity. And so, what Deutsche wanted was a lawyer or lawyers to come in and build a legal department, and that was of great interest to me. So Dick became global general counsel, and I, for the first 2 years, served as the global head of litigation and regulatory investigations, handling regulatory or criminal inquiries to the bank or internal investigations. And then after 2 years, Tim Myopoulos, who had been the general counsel for the Americas, who had come in with Dick and I, moved on to Bankers Trust, and then so I took his position, and for the last 5 years or so was general counsel of the Americas.
Okay. I do want to get us up to the SEC, but because I know that the Deutsche Bank work eventually influenced some of what you did at the SEC, can you talk a bit more about what you did? I think you said global counsel for the Americas for a number of years?
General counsel for Americas for 5 years. Look, you're the general counsel, so you are responsible not just for the litigation and the regulatory work, which I had been doing, but you are supervising a legal department that consists of lawyers transactional lawyers who service all the businesses, and Deutsche had many fixed income, equity, lending, structured products, asset management, private wealth management. They had many businesses, and so, the lawyers who service those businesses were in the legal department. Then you had the litigation and regulatory lawyers. You had the HR lawyers, and then you were part of a global legal department. So, you thought a lot about structure and organization of a global legal department. How do you manage that? How do you structure that on a regional but also on a global basis? And then, of course, then the financial crisis hit in 2008 when I was still there. So the last part of my tenure was very much spent focusing on dealing with the financial crisis, how the bank was going to, deal with transactions, deal with the increased oversight, deal with the fallout, unwind transactions and things like that. So it was a challenging time.
Okay. So by the end of 2008, now we can turn to the SEC. Clearly the Enforcement Division had taken a couple of public relations hits. First of all, there was complaints about the financial crisis, and then more specifically the Madoff Ponzi scheme came out in December of 2008. And you joined the SEC as Director of Enforcement in January of 2009, I believe?
That's right. I think I signed up in January. I started in February or early March.
How did you, what did people reach out to you? How did you get connected to the SEC, and how was that job offered?
Well, Dick Walker showed up in my office one day and said, I think Mary Schapiro is going to give you a call. And this was probably a month after Madoff had confessed. And, we're still in the turmoil generated by the financial crisis. And I think just to fast forward ahead, I think Mary's thinking was, and she was the newly appointed chairperson. In fact, I think she had been maybe the second or third appointment that Obama made, reflecting the importance of that position and the critical nature of getting a chairperson in that role who could start to deal with the crisis situation. So I think she may have been sworn in December, within a month or 6 weeks after Obama had been elected. I think maybe the Treasury Secretary had been appointed before that, but not many others. And so, Mary, I think, was looking for someone who, one, had a prosecutorial background. I think she very much wanted to send a message that we were going to take a hard look at financial crisis-related misconduct. And two, I think she was attracted to somebody who had worked in a financial institution and understood some of the markets and the products and the transactions that were implicated by the financial crisis. The SEC did some work in those areas, but primarily was was a equity sales and trading focus through the enforcement division. I mean, they did other work, don't get me wrong, but the products in the markets at issue now were derivatives, structured products, fixed income, credit products, and so I think she was looking for someone who had experience in those as well. So Dick was right. She reached out to me, and I met with her, and she eventually offered me the job.
Did you have any qualms about taking it at such a time when there was so much turmoil? Both I should say, probably where you were working and where you were about to work.
I didn't. I will say that, look, it's a job that I had always looked upon with sort of great admiration and desire, even frankly. Didn't think it was a job that would ever come my way. But the people who had served in that position, Steve Cutler and Dick and Bill McLucas and others I knew, and it seemed like such a fascinating opportunity, and to take the position at that point in history really only increased the attractiveness for me. Once I got over the hurdle of moving the family to Washington, because you couldn't do the job from New York. Mary wanted people there in the office by her side in order to do the job, and I think that was very much the right call. You couldn't commute to that job, so it was very attractive to me. I must say, I don't know that I fully appreciated the crisis nature of it. I mean, I was in New York, and of course, I knew about Madoff, and I knew very much about the financial crisis, but the political fallout and the particular ramifications for the SEC were not obvious to me until one day I was walking down the hall at Deutsche Bank, and I think somebody had a television on, and I happened to glance in, and it was congressional hearings, I think maybe in the House Oversight Committee, and I think the 5 division directors were there testifying, as well as the general counsel. And it was a very, very inflamed and antagonistic interrogation, highly critical of the SEC folks by the congressmen. And so I saw that, and I thought, oh my gosh, do I really know what I'm getting into here? At that point, it was too late, and I wouldn't have turned back anyway. But that was the first realization that things were really hit home, that things were hot in Washington.
Okay. I want to talk in a minute about some of the particular changes you made, but at the time you walked in the door, what was your sense of the morale of enforcement, of what people at the SEC were thinking in the aftermath of certainly a huge amount of public criticism and I think self reflection over the Madoff?
Well, I don't think I had a sense of that when I first walked in, but in a pretty short order, I think it was pretty clear that the institution had taken a hit. There were highly critical comments and statements coming out of Congress, including threats to cut the funding of the SEC, even some threats to cut out big pieces of its jurisdiction, maybe cede its authority to the CFTC or the banking regulators. So there was a real challenge to the existence, an existential challenge to the institution. There was obviously highly critical commentary in the media and the journalists, and look, rightly so, at least in terms of raising questions given Madoff and the financial crisis. And I think my sense was that the individuals at the SEC and the enforcement division in particular were, look, they're professionals who in many cases had spent their lives working at the commission and making cases, took great pride in what they did, and to be working in that environment caused people, harm and hurt and embarrassment even. It used to be said, I think, that people would go to dinner parties or the like, and they would say with great pride that they worked at the SEC, and now the commentary was that when they went now, they didn't say what it is that they did because they were afraid of the questions that would come their way. And so, within a short period of time, I realized that the institution really was not only under attack, but I think looking for some direction and a path and some leadership as to how to deal with this situation.
So what path did you want to set the SEC on, or I should say enforcement division?
Well, look, a couple things. I had some ideas about specialization
Yes.
and organizational structure. I was the first enforcement director who never worked at the SEC, and the first one who ever worked at an in-house job. And I think, being an outsider, under some circumstances, isn't necessarily an advantage in an institution, right, or a private company.
Sure.
Succession planning, you often maybe want to recruit from within rather than bringing in from the outside. But there are times, I think, when it's beneficial. And this happened to be, I think, a time when it was beneficial because I was not beholden to any particular structure, any particular personnel decisions, any particular path. And so I had the advantage of being able to look at things anew and perhaps take some steps that would have been more difficult for someone who had come up through the ranks to take. Two, I had the advantage of really a great appreciation for the complexity and challenges of some of the products and markets and transactions that were really the heart of the financial crisis. As the general counsel at Deutsche Bank, when I had to make some risk decisions about some structured mortgage products or some complicated derivatives, I'd go into a conference room with three of my lawyers and five of the folks who worked on the structuring desk, and we'd get the whiteboard out and map out the transaction, every box, every dollar flow, and flush through that in a way that allowed you to understand what was really going on. And it gave me a great appreciation for the expertise, and I think it's that idea that eventually spawned the decision to go forward and create specialized units in part of the enforcement division. And third, I was the great beneficiary of Mary Schapiro and the commissioners, and really everyone, including the staff, who were open to the idea of change. They didn't like what had happened, and they were sensitive to it. And to their credit, they recognized that there's some things that they could do better. So rather than resist or fight back against the accusations, we adopted an approach of we will listen to any idea, we will learn from it, we welcome the criticism and the observations, and we will go forth with a restructuring and reorganization plan that will address those concerns and will make us better going forward. And people, bought into that vision, and that's not an opportunity you get very often. Private industry, yes, even more so, I think, in my experience in public institutions. And so it was to use the overused cliche, it was the perfect storm, but that we used it to really launch some changes that I think were beneficial.
So you didn't find significant pushback from the staff with innovations or the fact that someone was entering who had not been on the staff before and had a different career path?
People pushed back against particular aspects of it, and by push back I mean ask questions for the most part that were the right questions to ask, but they didn't challenge overall the need for some initiatives and some programs. We had a great deal of debate about what the right package of those reforms were, but ultimately the status quo was not something I think that most people were thinking should be maintained.
Okay.
And some of these ideas, quite honestly, I had some of them, but some of the ones that we eventually embraced were ideas that had been laying around in the shelf at the commission for years, right? I mean, to some degree, it's the staff who labored under certain processes or certain approaches, who could see better than anyone, what kind of reforms might allow the commission to expedite, the enforcement process or gain better expertise or become more efficient. They had those ideas, and so we encouraged people to take stuff off the shelf or go out and bring new ideas wherever we came from. And a great source of some of the changes we made were from the staff themselves.
Okay, so let's talk about some of those changes. And I think you've already led up, you've given us a good introduction to them, but one thing that was observed is that fairly quickly a wide-ranging reorganization of the enforcement division was started, especially the creation of a number of specialized units. And if you can expand on your earlier explanation, why move to that level of specialization?
Look, I think it was pretty clear to me the advantages of specialization. It's not to say that the SEC was not specialized, because it was, and they had done task forces, over the years to address particular problems. But there weren't permanent structures in the enforcement division to deal with the main categories of cases that the SEC had done. And it was my view that if you're really going to investigate how a CDO is put together and be able to find the fraud, you need to be smart about those products. And the way you get smart about them is to do a steady diet of them over time and to create these centers of competence within the division where we could target training, where you could attract people who really wanted to do those kind of cases, where you could hire from the outside. There were many folks who lost their jobs as a result of the financial crisis, or just people who wanted to wear the white hat for a while because they didn't like what they had seen. And if you could point them to a particular place in the enforcement division, we can hire you as a fellow, and you're going to be part of, the structured products unit. And you used to structure mortgage products at the desk at, JP Morgan Chase. Well, now you're going to be advising enforcement lawyers about how to find fraudulent ones. And that was very attractive to people. And you couldn't really do that if you didn't have a home for them in the division. I mean, you could hire them in general and say you'll be working on structured product cases, but it was more attractive to them to really be linked to a particular entity. And so we did that. We brought in specialized training for these people. We consolidated cases within those units, and they all went off and did offsites for a couple of days where they got smart about the products and did the training and went out and read the academic journals and surveyed the literature and met with experts in the field, and they started looking at cases, and they could get to the heart of it much quicker. They were engaged, they were enthusiastic. It was, in my view, beneficial for targets of those investigations and defense lawyers as well. You'd rather have a smart and informed regulator who will be able to see earlier on that the thing that looks sort of suspicious to them may in fact be normal market practice, or has an easy explanation, or they've seen the same thing 3 times previously, so that they could shut down cases sooner as well. And so there were a great many advantages to it. It was a challenge because the SEC had historically only been organized regionally. The New York region, the San Francisco region, the Dallas-Fort Worth region, and each regional director was in charge of everything that happened in that region, whatever the nature of the case. So we laid over that structure, this regional structure, these specialized units which were across the country. And so they may have had a chief in New York and a deputy chief in Atlanta, and staff in the unit in 5 of those regions. And so you had regional directors who no longer had full autonomy over their cases. And in fact, people in their in their regions, yes, may now be reporting still to the regional director for some cases, but to the head of the unit in New York. Well, that's the kind of organizational change that, as I'm sure you recognize, can cause some difficulties. Completely understandably, people don't like to, give up, yes, their autonomy and their authority, and they questioned whether or not structure worked. But at Deutsche Bank, I had seen these things work because there were matrix reporting is the fancy organizational term for it, but it exists everywhere. You would have regional reports, as a fixed income lawyer at Deutsche Bank, you reported to the general counsel in New York, or perhaps the head of the fixed income, but you also reported to, and helped the desk in Hong Kong do work, and so you had lines into those other regions as well. And so it's really just the same kind of thing. And look, it took some time to iron out the difficulties, but I give great credit to the regional directors. They eventually, bought into that approach. And I will say that one of the most satisfying things about the specialized units is that while I brought in a number of outsiders to the commission to fill regional director positions, mm-hmm, for these specialized units, and there were 5 of them, I recruited solely from within the commission for the people to be the chiefs of those units and the deputy chiefs or the co-chiefs. And it was a wonderful thing to see. These were mostly These were not associate directors. These were not people who were already at the top of the management chain, if you will. I recruited mostly from the assistant director level. And these are people who you gave them this mandate and said, and these were people who had, typically had done these cases and were smart and well regarded. You said, here's what we want to do. You're going to build it. We're going to give you 15 slots, and you're going to hire a couple of fellows, and here's a bunch of cases to start out with. You build it. Here's the mandate. And to see those folks react to that in the way they embraced that opportunity with eagerness and drive and enthusiasm was really very, very, very satisfying. And those units, they remain intact today. And so I think that shows that they've been a success. They were never designed to be static.
Yes.
They can shrink if it's no longer as significant. That subject matter is no longer a significant priority for the division. They can expand. Not all the cases were of a particular type were done in the unit, right? We had an FCPA unit, but there were people outside of the FCPA unit doing FCPA cases. And when we did that, you had the unit there as a source of competence and excellence and expertise that others could consult with. But you didn't want to vacuum up every case across the division because you didn't want to create a two-tiered system,
Sure.
Where somehow, the specialized units were viewed as, where the real action was and where the best cases were. You wanted everyone to share in that. We also didn't want, in the bank, you became used to what's called implementation risk. Banks and private companies used to call it it's like the Mao Zedong theory of perpetual revolution. Some institutions are constantly in restructuring. And I wasn't confident enough to know exactly how this was going to play out. So I didn't want to start out by specializing 50% of the division.
Of course.
Right? Because if it was a great idea, but you stumbled on the implementation, then the idea would be discarded and rejected as saying it was never going to work, when it really wasn't the idea that was the problem, it was the implementation. So we started with about 25% of the division specialized. And I think that was the right way to go. And then over time it expands and contracts depending on the market situation.
Okay. Quick question. So were you were hiring experts from outside who were not lawyers, subject matter experts. Was that an innovation? Was that something that had been being done before?
I think it might have been done a little bit, but
Okay.
not to any great extent. And so these were ops guys or women,
Yes.
structurers, risk managers, and people who just understood the products and the transactions, and they were very helpful. The other thing the units did, I should say, is it created great cartilage across the division. You used to have people across regions working together, but not that often. Well, now, you got an asset management staff unit in San Francisco working with somebody in Boston who's in the asset management unit. It started to create real cartilage across the division, which was lacking a little bit in a siloed kind of structure, and that was beneficial. People just got to know each other and work together, and it was very helpful. The other thing it did is just it's knowledge management, right? It is fundamental to a private company. The SEC had such great expertise, but it existed mostly in the minds of the individual SEC lawyers who worked on a case, right? So if you had this really complicated gap revenue recognition case in a Silicon Valley startup that somebody in San Francisco really knew, and you got the similar case in Atlanta, you might stumble upon that person, or you might find it quickly, but it wasn't obvious where it was. And these units served as really reservoirs of knowledge, so that not only would all the knowledge and experience be in one place, but for years going forward, that would be accumulated and carried forward, and people could tap into it. And so, it's the knowledge and the expertise that's the greatest asset that the division has, and this was a way of really collecting it and preserving it and making it available.
And you also flattened the structure a bit, I understand. You eliminated the branch chiefs.
That's right.
Why do that?
Well, once again, at the bank, there was always all sorts of management shuffles, but what I learned was that two things. One, the U.S. Attorney's Office has a very flat management structure.
Okay.
For the securities fraud unit, there were probably 15 or 20, maybe 22 prosecutors, and there was one chief and one deputy. And for a long time, just one chief, not even a deputy. So what's that ratio? 20 to 1, right? Or 22 to 2. The SEC, when I got there, the first things I asked for is, well, can you tell me what the staff management ratio is? And the information took a little while to accumulate, but when I got it, it was something in the order of 3 or 3.5 to 1. Meaning there's one manager for every 3.5 staff members. And that was just at the first level management structure, the branch chief level. And then beyond that, you had assistant directors, associate directors, deputy director, the director. You had 5 layers of additional of total management. And I looked at that structure and said it didn't make sense. And it got that way not because of any impropriety or wrong thinking, but in the government, how do you reward top performers? Well, you can't really pay them more. So you give them a management role and a title. And so they became branch chiefs, and they got a little bit more money, and they supervised, 3 or 4 or 5 people. And that makes sense from maybe on an individual basis, but if you step back and look at the structure that you had created, it's a management structure that looks like this, rather than like this. And the other thing it did, I think, inevitably, it just created inefficiency and bureaucracy. What that meant is, for example, in drafting an action memo, it went through 5 layers of review or more. And what I wanted to do is I wanted more autonomy and more independence to be driven down into the organization at the staff level, give them more ability to pursue their investigations with still sufficient oversight, but not needless oversight. And I also wanted the challenge was that at the commission, to some degree, because so many of their cases settled, at the U.S. Attorney's Office, the goal you're striving for in the end is really, the actual investigation and the trial and the conviction. At the SEC, unfortunately, what happened is that the thing that the staff members kind of, to some degree, yes, they wanted the settlement, and that was very important to them, but the process of approvals became such a big part of the process that it disproportionately occupied their time and to some degree almost became like the goal.
You mean approvals all the way up to the
All the way up
commission
to
for a
commission,
settlement?
right, and just doing the perfect action memo because so many people were looking. I will tell you, anecdotally, and I actually looked at this, there was one action memo that I recall that we went back and looked at the electronic communications associated with it, and it went through nearly 70 drafts, 7-0, back and forth, back and forth, back and forth. You can't run an organization that way. And so, and I also wanted these branch chiefs, I wanted the thing to be the focal point of the division, the thing that people took their pride in, the thing that was really the reason they were there, to be the investigations. And so I took the branch chiefs and eliminated the entire position. That was 120 people. Not something that went over all that well, particularly with the branch chiefs. And those 120 people, they didn't lose their salaries, because that was prohibited, but they lost their management titles and they went back to the staff level. And then we re-interviewed some of those people, and of the 120, we hired back probably 20 or 25 to become assistant directors because we wanted to target a roughly 7-to-1, give or take, staff to manager ratio. Like with the specialized units, I didn't want to leap to 10-to-1 or 15-to-1. That may have been, too much to handle. Plus, it was flexible, so you could always change that over time by not replacing managers or adding staff. And so, what resulted from this is a couple of things. One, by rehiring about 20 or 25 of the former branch chiefs to be assistant directors, you're able to pick the best 20 that you thought out of the 120, right? And so that gave you a chance to really, enhance the quality of the managers because you're able to pick from amongst a series of experienced managers, which ones you really thought were the best for the job. Two, I think we learned that a lot of the branch chiefs didn't love being managers. They wanted to be investigators. That's why they came to the commission. And they couldn't really turn down the branch chief promotion when it came because it's the standard of success. But once they got over the kind of maybe a little bit of the shock and hurt of losing that title, they went back to being investigators. They were sort of emancipated from the management responsibilities, didn't mind that, were back to doing, kept their pay, and weren't necessarily unhappy with where it all came to rest. And so, I thought that was helpful, and things, along with other, changes, really began to make things move more quickly.
So in the same vein, you also got authority for formal investigations, I believe, was devolved from the commission. Was that something that was important to you to bring that down? If you could explain that a little.
That was important, and that was one of the ideas that really came from the bottom up, I think,
Okay.
something that had been debated for a while within the commission. And look, I don't want to overstate how much time was spent getting approval of a formal order, right? It was typically done, all the formal order requests were put on a sort of a summary calendar and voted on by the commissioners as a group. And if any one was of interest to a particular commissioner or wanted to hear more about it, they could pull that off the list and it would be discussed at a commission meeting. But that process was still pretty quick. And of course, if there were any emergencies, like a needed emergency TRO, you could get that approved, immediately. But it still required the writing of a memo, a couple, 2-3 page memo, and had to be reviewed through the process. And I think so. As much as it was inefficient from the sense of the time that was spent doing it, delegating it down to the associate directors was just really psychologically, I think, a statement of faith, and driving autonomy and authority down into the division where I thought it more accurately belonged. Let the associate director, the head of the New York office, if they think a case should be open, well, we should trust them to be able to make that decision. They don't need that to be approved by me in Washington. The other thing we did is we did a study of how many of these formal orders had actually been turned down as the decision as to whether or not it was really serving a purpose. Well, we went back some number of years, and I think of the hundreds and hundreds and hundreds, I don't think we found, if we found 3 that had been turned down, that might be an overstatement. It was very rare. It's not to say that there weren't discussions about them,
Sure.
and maybe even some were amended in a way to satisfy the concerns of a commissioner. And I also understand, look, there's an argument that structurally the commission just ought to be aware of what the enforcement division is investigating, right? They're the ones that are, the enforcement actions are brought in the name of the commissioners. They ought to know. And there's also an argument that, the smartest time to make a decision about a case is earlier rather than later, because once a case is in investigation for 6 months or a year or 2 years, it becomes harder to shut that investigation down. And so by looking at things more closely early on, you can make better informed decisions about those cases that really aren't going to get traction and should be closed. But I think on balance, the way we did it was the right way by delegating it. We created some summary reports every quarter where we let the commissioners know about what had been approved. And so there were ways to make sure they were informed, but I think it streamlined the process and sent a message of faith and confidence in the staff.
Okay. So it's interesting you talked about sort of looking back quantitatively some, trying to figure out what happened in the past, because I know that there was a different use of data analytics that I believe came about the same time that you became director of enforcement.
That's
if you could, so was that something you brought from your private practice experience? Was this coming from a different direction?
It really came from the bank. In the bank, you don't do anything without a deck, without a PowerPoint. It's just the oxygen of life in a financial institution in terms of management aids. And so when I got there, there were what you would expect, right? There were some priority lists and other types of management information that helped you run the division. But what I was interested in is more data analytics around evaluating, how the division is operating. And so we did two things. One, we had a kind of a homegrown system called the Hub, which was the repository of all case information. And it took like 3 or 4 months to just scrub that and make the data clean. So we had to get all the staff members to review the cases assigned to them, close the ones that needed to be closed, update the ones that needed to be updated, so we had clean data. And then we ran some simple metrics. The simplest of one being, for example, how long from the time a case is opened to the time that you file your first action. And we created a bar chart and put every associate director's name on the left-hand axis and the timeline on the bottom. And there, in 1 second, I think for the first time, you could say which associate director groups are moving their cases and which ones aren't. Now, like any piece of data, it's just a starting point, right? Because then you would bring those associate directors in, you would say, look, you're averaging 46 months. Somebody else is averaging 27.
Sure.
Why do you think the difference is? And there were times that there were explanations for that. For example, somebody who does a lot of TROs or Ponzi schemes is going to have a quicker gestational life than somebody who's doing FCPA cases with offshore evidence. So there are explanations for it. But for the first time, the associate directors themselves, they were held to be responsible for the progress of their cases. And there were similar metrics like that. And then there were also quarterly reviews where we get printouts from this hub of every case in every associate director group. And we would bring them in every 3 months. And we would start at the back of the printout with cases that have been open, were still open from the 90s
Sure.
or something, and find out what's going on here, what's the next step. All right, take those 2 steps, report back at the next meeting, and at the next meeting, you'd have notes about what had been decided upon, and then you would make a decision at that time. And so that just, it's like anything else. If people know that their work is under observation and being looked at, and they're going to have to explain why it is that something happened or didn't happen, they're going to be responsive. And so that was helpful from a data point of view as well. We also did data analytics around risk analytics, and this came out of Madoff primarily. If you read the IG's report and all the various reports about Madoff, and the fact that the exam folks had been in Madoff's businesses and his locations, and were actually concerned about allegations of it being a Ponzi scheme. And the enforcement division had opened 1 or 2 investigations of Madoff and eventually closed those because they ended up looking at things like whether or not he was running an unlicensed broker-dealer rather than a Ponzi scheme. And so, look, that was deeply troubling. Why is it that we couldn't figure out the problem? And of course, specialization is one answer to that. Just being smart. When you went in there, he was told the world he was running a split strike option strategy. Had we known probably more about some of that and what that means, and we got very close because people recognized, well, if he really has that much money that he's managing and that's a strategy, there should be a massive amount of options trading that goes alongside that strategy. And we went to the banks. This was before I got there, but
Yes.
Went to the banks and looked for the exchange-traded options, and there wasn't the volume that would have supported it. So the only other explanation was that it was over-the-counter options trading, which is what he said was going on. And there were even phone calls to European banks to find out if there were over-the-counter options trading with Madoff's entities. And you know what? Some of those phone calls just weren't returned or not followed up on, and had that happened, history might have been different. And so what we did around data analytics, though, is, the SEC has only, the enforcement division has, 1,400 people in it and probably 700 or 800 enforcement staff. And similarly, the exam authority doesn't have limited numbers of people. So what you want to do is take, there were thousands of registered broker-dealers and investment advisors. You can't look at all of them. The exam staff can't examine all of them. So what you would want to do is take some risk criteria and apply them across the board and see if that reveals certain advisors or broker-dealers or others who start to have some of the characteristics of some misconduct or crimes for which there's a certain template. So if you got an investment advisor who is running a strategy that is, year in and year out, 5% above the benchmark, so that if they're running a long-short strategy, and every other long-short strategy across the globe averages, has averaged 7% returns in the previous 5 years, but you've got somebody who's running 12%, and it's pretty static. It's not volatile at all.
Yes.
That pops out of the system. You can say, I'm gonna take a little focus and look at them because that strikes me as potentially a little risky.
I have to jump ahead slightly because this was a question I was going to ask later. There was some media coverage after you were quoted, fairly or not, as saying that anyone beating the market indices by 3% steadily would be a target of investigation. And I don't know if that was a fair quote or...
Yeah, that's not. That's
okay.
That's obviously, yeah, you couldn't quite do that.
Yes.
But what it attempted to capture is the notion that you come up with some risk parameters, returns, volatility, and things like that, and you run that through a large database of entities, and then whatever comes out of that, you start to take a closer look at. There might be a perfectly good explanation for it, but that way at least you're focusing your limited resources on 20 entities rather than 1,000. Because if you're focused on 1,000, it's going to be a needle in a haystack. And so we did that in various areas, including investment advisors, broker-dealers, and the like. And that kind of stuff still goes on. Now, I think even there's data mining that goes on with Corp Fin filings, so that and some of this was automated through data crawling mechanisms where, if every oil and gas exploration company in the sector, is writing down reserves in a particular quarter, but there's one that isn't, you might want to know that to figure out whether you should go knocking on the door of the one to find out why it is that they're differently compared to. So a lot of that really helps you be much more efficient.
So it's interesting. So I've now gotten in this interview a very clear picture of how your background at Deutsche Bank influenced some of the changes you implemented in enforcement. But clearly there was attention to the fact that you were the first federal prosecutor who was heading enforcement. And your deputy, Lauren Reiser, was also a federal prosecutor, the head of the New York office, and later on you named some former U.S. or AUSAs to head regional offices. Do you think that aspect or that side of your previous career, how did you bring that to the Division of Enforcement, or did it change what the division did?
Look, I know there was a fair amount of discussion about that. Somehow I was turning the SEC into, another arm of the Justice Department, and some people thought that the criminal perspective was inappropriate to bring to a civil regulator, and there's certainly validity to that. But I didn't look at it that way. For me, it was much simpler. One, I knew these people. I knew them to be highly talented lawyers. I knew them to be both prosecutors, but also defense lawyers. I mean, every one of them, with the exception maybe of the Miami regional director I hired, were both former prosecutors, a number of whom I'd worked with in the securities fraud unit, but had been defense lawyers. And so I wanted people who had seen both sides of it, because as defense lawyers, they can also, understand from the defense perspective what it means to be on the other side of an investigation. I like the fact that they grew up in a system such as the U.S. Attorney's Office, where again the real focus was on the investigation. The oversight and management was enough to provide proper oversight, but not more than was necessary. I like the fact that they were on the outside coming in. Again, I thought that for this particular point in time for the division, that was a helpful and healthy perspective. And so I hired former prosecutors to be my deputy, to be the head of the trial unit, Matt Martins, to be the head of the New York office, George Canels, to be the head of the Atlanta office, Rhea Dignam, to be the head of the Miami office, Eric, forgetting Eric's last name. And I think that was it. I did other hiring, but they were not former prosecutors. David Woodcock
Okay.
ran the Fort Worth office. He had come from he came from an accounting background, but not a former prosecutor. And then, like I said, all of the heads of the specialized units were recruited from within. And so, the former prosecutors that came in, there was a number of them, and more than there had ever been before, but they were not, the place wasn't dominated with them. There was other hiring that was going on as well, but I liked them because I knew and trusted them, and they had a wealth of experience that I thought was helpful.
Right. And you beefed up the trial unit.
Beefed up the trial unit. Look, the trial unit was strong, but I felt that it needed more active supervision. It tended to be, and I don't remember how many folks were in the trial unit in Washington. Might have been 20 or 30. They operated pretty independently, almost like solo practitioners. I mean, they had supervisors, but
Yeah.
I don't think there were regular practices of reviewing every submission that went to the court, or other what I thought were pretty fundamental aspects of managing the unit. And so Matt Martins came in, and then Matt Solomon came in as his deputy. Matt Solomon was also a former public corruption prosecutor in the U.S. Attorney's Office in D.C. Matt Martins was a former prosecutor in the U.S. Attorney's Office in North Carolina. And they came in and I thought did a great job of really just taking a close look at the trial unit and making some changes. I thought made the unit really strong, and better interaction between the Washington trial unit and the trial units in the various regional offices, which reported to the regional directors, but we created some more cartilage in the trial unit across the division.
Okay. So let's now turn to some of the actual investigations and matters you dealt with while at the Division of Enforcement. But one way to start is to ask you about the coordination because obviously financial crisis cases were a concern across a great many agencies, and sort of the particular focus the SEC chose to take. I know there were a couple of big task forces. You were on the financial fraud task force, and then the RMBS task force was started, I believe, in 2012. And I was curious what your role there was and how you carved out a particular place for the SEC amid so many perhaps jostling agencies wanting to be involved with that.
Yeah. Well, the SEC had a leg up on this because we started looking at structured products and RMBS securities. I think some of that may have even started before I got there, but certainly really ramped it up in 2009 with the creation of a structured products unit. I mean, that was really their focus: mortgage products, structured products, CLOs, and other instruments of that nature. And so we had an early start, and began to bring in the experts and issue the subpoenas and collect the information and start to conduct investigations. I think our first case was probably Goldman Sachs, the Abacus case, which I believe was filed in 2010.
Okay.
So that was, a year and a half, 2 years before the RMBS task force. And we brought a number of other cases before that as well. So when the task force were created, the Financial Fraud Enforcement Task Force was chaired by, I think, Eric Holder as the Attorney General, and had 60, 70 different federal and state agencies. It was not so much we're going to collectively go out and investigate cases, but it was more an information sharing and expertise sharing function.
Okay.
And plus, the SEC didn't really need to rely on a task force to be able to coordinate with other law enforcement partners who were going to be important to the effort. We had a 40-year relationship with the Southern District Securities Fraud Office. We had relationships with other U.S. attorneys' offices. We had relationships with the CFTC and FINRA and others. And so we were already well integrated with other agencies. So we were off on our own already. And in all candor, the federal Financial Fraud Enforcement Task Force wasn't a big difference for us. It helped others, but not so much for us. Although it did bring to us like people from Fannie Mae and Freddie and some of the IG's offices, and so they were very helpful in some cases. So it was beneficial in that regard. The RMBS task force was created after the first mortgage settlement, which involved really much more of the the mortgage origination side and the documentation side, foreclosures, and it was a big settlement of billions and billions of dollars across that bank. And then it was signed off on by the various state attorney generals, but one condition, I think, of that settlement, particularly for Eric Schneiderman of the New York State Attorney General's office, was he would sign off on that settlement as long as there was an effort at the federal level and through a task force to look specifically at the securitization side, at the Wall Street side. And so I was co-chair of that along with him and Tony West of the Justice Department, and Lanny Brewer, head of the criminal division. And that was a group where we first thing we did was we brought all of the agencies in that task force to the SEC for like 2 days of training by the SEC. So we brought our structured products people, the people in the unit, the outside experts who we had hired, and we did a tutorial for 2 days, and then we coordinated on cases going forward across the board. And so the RMBS task force, I think, was helpful in that regard. Again, we were already in that direction and making the cases, but I think it was helpful overall.
So during your time at the SEC, there were a series of major settlements reached with various banks and financial institutions. And one of the questions I just wanted to ask up front is, they often would focus on a particular transaction, for instance, Goldman and Abacus. Was there a sense, how did you, if at all, how did those particular matters come to the SEC's attention, or come to be the ones that, at least in the public, it seems there was a focus on?
Well, certainly for Goldman Abacus, not surprisingly, the Goldman name meant that it attracted a bunch of attention from the press, and it was really the first significant credit crisis-related case concerning a bank.
Yes.
And for that reason was also of great interest. There was a lot of, as you might imagine, media interest and commentary on why have there not been prosecutions of the banks and particular individuals at the bank. A narrative that continued throughout my entire time, ultimately more focused on the criminal authorities and why the Justice Department hadn't brought more criminal prosecutions in that space against individuals. But the Goldman case, because of the name, because of it being one of the first, and also it sort of coincided with the bailout-related debates in Congress, and then the passage of Dodd-Frank. And so, and because it was 2010, I believe,
Yes.
still relatively fresh in the wake of the credit crisis, and all that came together to really make it a focus of everybody's attention.
Okay. And I guess there were similar, the Bank of America matter in 2009 about the Merrill bonus payments also got a lot of immediate attention. And then a year later, the city settlement in 2011.
Countrywide
Yes.
was one of the first cases that we brought, where Angelo Mazzillo paid a $60 or $70 million penalty and disgorgement figure for some of the disclosure-related issues at Countrywide around the status of the mortgages and default rates or delinquency rates that they were seeing, and not being fully candid with their investors as to what that was going on. But yeah, there were a number of those cases. The Citibank case became well known for the issue around the use of no admit, no deny settlements.
Yes, I want to get to
and that was the reason for a lot of its focus.
Okay. Why do you think there was, I don't want to say a relative lack of individuals, but there was certainly a public perception that Mozilla was unusual, Goldman Sachs, one individual was targeted, but there were, at least the public perception was, there were a relatively limited number of individuals being called to task for their roles in the financial crisis?
Well, look, first of all, I think there's a bit of a misperception across the cases, including the credit crisis cases. We brought cases against individuals in most of those cases. I think we actually looked at the numbers, and I don't know, there were maybe 70 or 80 or 90 cases that could be classified as credit crisis related cases, and I think all but a handful we brought cases against individuals. To my handful, I think under 10, maybe under 8. and in some cases many individuals. I mean, we sued Fannie and Freddie and sued 6 of the most senior officers. Angelo Mazzillo, the head of Countrywide. We did sue individuals in Citibank and Goldman. I think the issue was one, it's a little complicated. One, first of all, you got to remember what kind of transactions we're talking about here. We're talking about structured product transactions that are typically being assembled, on a desk of some nature, the structured product desk or whatever it is. And that's the bank's machinery that purchases the mortgages and packages them up and does the diligence and sends them out. And so these transactions are often not ones that are rising up to the executive suite level. So when people would say, why wasn't Lloyd Blankfein or Jamie Dimon sued in the financial crisis? Well, these transactions on an individual level were simply not elevated within the organization to those points.
Okay.
And so they were just unaware of them. They obviously were aware of the aggregation of the profitability of those banks and risks when it would show and things like that, but they weren't putting the deal together. Second of all, lawyers were crawling all over the deal. And I don't mean to say that just because you have a lawyer in the conference room, that means that you're immune from liability, but what it means is the lawyers were there to make sure that the disclosures were accurate and diligence was being followed. Third, the disclosures on those cases involve typically whether or not, or were characterized in terms of conformity with underwriting guidelines. So the main representation that would be the hook for an enforcement case, if there were to be one, is that, the mortgages in this pool, conform to underwriting guidelines, or would they say conform in material respects to underwriting guidelines? Or if there were going to be deviations, they would say, no more than 4% will deviate from underwriting guidelines. Or they will say, either they conform to underwriting guidelines or they have other characteristics that overall make them, acceptable for inclusion in the portfolio. So when you're trying to hang a hook on a misrepresentation based on that kind of language, it's not easy and not obvious. You've got to be able to show that a certain, non-disclosure or omission was contrary to that representation. And, so some mortgages that didn't conform to the guidelines were okay and were disclosed, that some would not. So you would have to show, pretty high levels of nonconformity. And so that's just not a simple thing to do. And often, as we would look very deeply through these mortgage portfolios, you wouldn't find mortgages that didn't conform to the guidelines. Now that may be a function in how elastic the guidelines are,
Yes.
but it wasn't obvious that was the case. And ultimately, these products, they may have gone delinquent for a while or come close to, cutting off payments to the equity holders, as the cash payments and the waterfall and how a structured product works. Those at the lowest seniority may have been at risk of not getting their payments, but ultimately, I believe all those transactions performed and performed, as represented. And so, I felt, some frustration as prosecutors and as enforcement lawyers. We in the Justice Department folks would like nothing better than to bring those cases. I mean, what possible reason would you not? I mean, in my experience as a prosecutor, line assistants and staff want very much to respond to the public or to allegations of crisis or improper conduct by bringing enforcement cases to show that to be the case. So there was no shortage of will or commitment, which is very difficult for those cases to be brought. And when they were going to be brought, they're going to be brought by the person who kind of sat on top of the deal or did the deal, because what you have to show for a securities fraud case is to show that somebody knew both that there were misrepresentations being made in the offering materials, i.e. that the mortgages weren't conforming to the guidelines, but also knew that what the disclosure was that said something to the contrary. And the number of people who are going to have both of those pieces of information, it's not going to be, again, the people in the executive suite. It's going to be the people who are putting the deal together, at the front lines. And so that, in my view, explains why, there weren't higher up individuals who were being charged, or there weren't the number of cases that perhaps people wanted to see.
Sure. So what was your reaction when Judge Rakoff famously was not apparently happy with at least a couple of the very high-profile settlements placed in front of him?
Look, I wasn't, I don't mind the debate. You're a public agency, you have a responsibility to listen to all critics or hear new ideas or new approaches and re-examine what you're doing to see whether or not there's a better way. And sometimes that can be painful, or sometimes, you take it personally, but you have an obligation to do that. And that's what we did through the whole restructuring. So, and also it wasn't the first time somebody had made that suggestion. The division itself over the years had debated whether or not no admit, no deny was appropriate, or should be modified or changed. We ultimately came out on the view, we did make some changes in it.
I believe there
With
was
respect to criminal cases, that you would require admissions when the same party had already allocated to a crime in a parallel proceeding.
Sure.
Which, it's kind of obvious that you should be doing that. But I think on balance, our view was that there was no real mystery when a company or individual, settles a case, pays a large fine, agrees to remediation, cannot deny responsibility as the policy required, because it was no admit, but it was also no deny. You couldn't distance yourself from the resolution. Engaged in a variety of reforms. Maybe you prosecuted the individuals. Maybe you went to trial where a jury found, liability. You look at the whole package. There's not a lot of mystery that a company or an individual engaged in wrongdoing and is acknowledging it. So I don't think we thought that the upside was that great to getting rid of it. And the downside, with respect to stringing out settlement discussions, companies being much less eager to settle because of the civil litigation consequences of making those admissions and other considerations. On balance, it wasn't something that I embraced. And the Second Circuit agreed, obviously, with us and reversed Judge Rakoff. Ultimately, when Mary Jo White came in, they revised the policy somewhat, although the number of cases was still small.
Yeah.
We were also concerned about the arbitrariness of how you implement that policy. Either you do it across the board, or you pick cases. And if you're going to pick cases, how do you pick which cases to do? And under Mary Jo, the commission articulated some criteria that would be used. I don't know that I think that observers would still say it was unclear why one cases would qualify and another one wouldn't.
Mm-hmm.
But that was a concern of ours as well. I think currently they're back much more to even fewer and fewer uses of admissions, and ultimately it may go away altogether, back to the way it was when we were there. So it ebbs and flows. I guess the thing I didn't like about it is that, this is just a personal observation, is at a time when the commission was really gaining traction and getting back up on its feet and driving reform to the organization and listening to the critics and changing the way we did things and aggressively moving forward, that criticism, stoked, a second wave, if you will, of commentary critical of the commission and its staff with what I thought were unfair criticisms. Not Judge Rakoff's fault, it's just, he's an influential figure, and for him to make those observations, then people in the media and the press pick up on it, and there were unfounded allegations of revolving door issues or whatever it might be, or afraid to try cases, and it just wasn't where the commission was at. And so it was a little bit of another body blow after we had picked ourselves up off the canvas and started standing up and fighting back again, to have that come again, just for morale purposes, wasn't great. That's not saying that's that's not Judge Rakoff's responsibility to be worried about that, and not a reason not to raise concerns, but I did see it through that lens.
Sure. So 2010 Dodd-Frank passes, is at least obviously a response to the financial crisis, is also supposed to give you some additional tools to deal with, give the enforcement division some additional tools. I'm thinking of the whistleblower provisions especially. But Did that significantly change, or did you view that as giving you substantial new tools to do what you do, or changing the environment a great deal?
Yeah, I think we did. I think we saw it as a very significant event, and we embraced it. Look, the whole point of the restructuring and reorganization was to make the enforcement division more nimble, more responsive, more informed. We didn't want to be bringing cases 3 years after the fraud had occurred, where there's no assets left to give to victimized investors, and the evidence is stale, and 2 of the defendants are in the wind. That's not a good enforcement template. And so all the tools that we had laid out were designed to make us quicker, more responsive, and smarter. And the whistleblower was a big part of that, for the obvious reason that the person best able to raise their hand early on in a fraud, when the money is still there and fewer victims have been victimized, and the culprits are still engaged in the crime, is a whistleblower statute, where perhaps somebody, the junior accountant, early on in a scheme, being asked to doctor up some revenue numbers, if they can pick up the phone and quietly call the SEC or go to the in-house lawyers, even if motivated by a financial interest. We were all for it. And so we embraced it, we endorsed it. Writing the rules was a difficult undertaking. Many people involved, I left that to others in the day-to-day writing of those rules, and people in the general counsel's office and the enforcement division and the chairman's office. Very difficult, because there were issues about who can qualify as a whistleblower. Should it be somebody involved in the wrongdoing, or does it have to be somebody who's not involved? What if they're criminally convicted? How do you decide how much money they get? Do they have to report in-house first, because you want the companies themselves to have the first opportunity to correct the problem, because they have fiduciary duties and they have an interest in learning about misconduct? Or do you require them to go to the SEC first, because you're worried that if you go in-house, they won't follow up on the allegations? So balancing these and many other issues, appeals and how you decide which cases are worthy, very difficult. But I think that the program has gotten a lot of traction. Cases have been made. I do think that there are tweaks and adjustments that'll be made as experience moves on. And it's not to say there's not a cost to whistleblowers. Look, the fact of the matter is that persons motivated in part by financial reward are sometimes, not going to be candid and forthright about what they're complaining about. Sometimes they're going to use it as a defense mechanism if they are faced with the loss of a promotion, or disappointed by their raise, or maybe they're in the threat of losing their job, and so they all of a sudden identify wrongdoing within the company. Those things impose a real cost on a company, and so how do you weed out those claims from the ones that are legitimate is a real challenge as well.
Not exactly connected with that, but it seems in the same bucket. You also moved to cooperation agreements, what some people call the C-board for individuals. How did you decide to add that to your sort of
those are standard tools for the Department of Justice, and we really wanted to do that for individuals, and we also wanted to allow individuals to sign a cooperation agreement and be able to give them a reduction in some of their sanctions in exchange for providing evidence, because the best evidence that you can have is an accomplice or cooperator who was involved in the wrongdoing, who can get up and testify. It gave us the witnesses to be able to take more cases to trial, which we wanted to do. It again allowed us to move more quickly. If you have a living, breathing person who can tell you about the fraud, you don't have to piece it together through bank records and emails in the same way, or be so dependent on those types of evidence. It was challenged because, in a criminal prosecutor's office, you can give a reduction off the jail time. That's decided by the judge. In an SEC case, well, some things you really can't give them a benefit of. We didn't want, for example, to give them relief from making restitution, because the victims needed to be compensated no matter what. And you also wanted to be careful about giving relief into certain other areas like, the injunction against future crimes. So you had to find some things that you can offer as the carrot, and that primarily is reductions off penalties and things like that. There were some difficult issues about bars and bars from the industry. Right? If someone engaged in fraud, normally they might be deserving of a 5-year bar or even a lifetime bar. Do you give them the ability to come back to the industry sooner because they cooperated? Maybe, maybe not, right?
Okay.
An interesting issue. But we really wanted cooperators, and then we wanted to be able to use deferred prosecution agreements and non-prosecution agreements for companies, a common tool on the criminal side, in order to offer that as an opportunity for those companies who, were going to engage in reform and had done all the right things in terms of self-reporting and disciplining individuals, et cetera.
Sure. So I know time is short. I want to ask one more substantive area, which is insider trading also got a great deal of new attention. That is, there was a Roger Rottenham case, the case against Matthew Martoma. I know SEC Capital was after you left, as I understand it. I don't know if the investigation was going on.
The investigation was there, yes.
Was going on. And I guess my question is, why was there suddenly an uptick in insider trading cases? Was there more insider trading? Was there the different approach that you brought to the division?
I think a couple things. It wasn't an approach I brought to the division. Like, one is practical and one is structural, I guess.
Okay.
The practical one is simply that that the wiretaps that came off of the Roger Rottenham case proved to be an incredibly fertile source of evidence. You have a wiretap up for a long period of time. You get a number of individuals who are detected on those wiretaps. Again, this was the Department of Justice's wiretap. Sure. Not the SEC's. We don't have wiretap authority. Mm-hmm. Those wiretaps led to cooperating witnesses, who in turn give you more evidence, which in turn allows you to go up on more wiretaps or start to engage in face-to-face consensually recorded telephone calls. And so it's just the momentum and the new doors that are open when you have a particularly fruitful investigation that spawns more cooperators, more wiretaps, more evidence. And you follow those paths. And so for the next, after those wiretaps were in 2009, I believe, for the next 2 or 3 years, cases were being filed that one way or another finds their roots in those wiretaps. In addition, it just raises the consciousness of people, and more people come forward and potentially offer evidence about insider trading or other misconduct. People in the industry are more fearful about the prospect of getting caught, so they're more open to the idea of coming forward. And also, I think the evolution of hedge funds, there's a lot of things about how hedge funds operates that makes insider trading perhaps, something that is more likely to occur just because of the nature of what they do and the importance of getting any edge in their trading strategies and other characteristics of things. Used to be in the old days, insider trading was mostly a function of large-scale mergers or acquisitions,
Sure.
and that would be what, as it got to the 2009, 10, 12, 13, it had to do with, how many iPhones were being shipped in a quarter, or whether or not someone was going to, hit their projected earnings or be a penny short, or more subtle, nuanced micro developments in the markets that be through the vast amount of money that hedge funds control, they could make a large amount of money putting a very big bet on a relatively small piece of information. Sure. So all of that contributed to it.
So I'll close with 2 questions. And the first question is about your reaction to your service, because you had clearly been in the public eye before with your work at the U.S. Attorney's Office, but as Director of Enforcement, you were dealing with Congress constantly. For instance, I believe you were called up to testify quite a few times, and how you responded to that level of scrutiny, either personally or how the SEC responded to a new level of scrutiny.
I didn't expect as much of my job when I took it to be involved, being outward-facing, particularly outward-facing to the many critics that were out there, Congress, the press, and others. And I certainly didn't like what people were saying. I was frustrated when I thought it was wrong, and I thought a fair amount of it was wrong, or at least its emphasis was inaccurate, or maybe more accurately, the story wasn't fully told. That there was a certain narrative that had taken hold, a pretty simplistic and high-level narrative, and it's hard to dislodge that from the minds of people across the country. There's probably nothing we could have done to do that, and I understand why they had the view that they did. I mean, look, massive credit crisis, businesses going under, people losing their jobs, a great deal of pain and harm. If I'm sitting on a bench in front of a pharmacy in the middle of Iowa, I'm wondering why there's not, 3 new wings being constructed at the penitentiary to house all the white-collar criminals who should be in there doing time. I understand the perspective, but I guess I didn't feel like it was frustrating that we couldn't respond to that view in a way that let people understand better how hard we were working and what we're doing, but some of the impediments to what they thought should happen. And so I didn't mind doing it. I was also proud of what the commission had done and what the staff had accomplished. It got a little personal, frustrating at some point toward the end where you just couldn't seem to move off that. But that was a small blip on the overall experience, which was very positive and rewarding and a source of great pride.
Okay, and my last question is, we focus so much on the directors, on the chairs of the SEC. Are there other individuals you worked with who perhaps didn't get the kind of public attention or deserve to be remembered in some way that perhaps is not going to happen if we keep the focus only on the very highest levels of the state?
That's certainly, it's certainly true. In the enforcement division, the line staff are the ones that day in and day out are doing the job, and cutting subpoenas and going through the emails and looking at the bank records and interrogating the witnesses, and those are the folks that deserve the credit, both building the cases as well as for the overwhelming part being open to change, which is never easy, but putting sometimes their own personal interests second to the interests of the institution, and that also is not easy, and so they deserve a great deal of credit. But really, up and down the division, it was really a big effort to move in this direction. The commissioners were very supportive. Mary Schapiro, as chairman, was especially supportive. All others across the board, really, it was an effort that everyone pitched in at, and really, I think, a source that everyone associated with the institution can take pride in.
All right. Looking back, how would you evaluate your time there?
It was, I guess I'll leave it to others to evaluate whether or not
All
it
right.
was a success. I certainly feel comfortable in saying that we didn't lay back and circle the wagons and ignore the criticism and put our head in the sand. We attempted to respond to it and to engage with it and do a lot of introspection as to how she would respond. I think what emerged was an improved division of enforcement that had better tools and better organization to achieve its investor protection mandate. And I personally, it was just a wonderful experience to be able to be part of that. Left with a sense of accomplishment. Felt like I left the campsite in better shape than when we found it, I and everyone else.
Yes.
And I really look back on the time fondly.
Well, thank you so much for your time. We really appreciate it.
My pleasure. Thank you.